On August 2nd this year, 27 countries start enforcing a law against AI systems. This date is 3 months from today. The law was passed in July 2024, 2 summers ago. It has had 22 months to settle. The text is finished, the courts are warming up, and the inspectors are getting their badges. Only one thing is still missing: a working definition of what they're enforcing it on. Article 3, paragraph 1 is where the law tries to define an AI system. I want to read it the way a court will read it. A machine system that is designed to operate with varying levels of autonomy, that may exhibit adaptiveness after deployment, that for explicit or implicit objectives infers from the input it receives how to generate outputs. That's the legal definition. You can check it out. The problem is that a spell checker fits that. A thermostat with a learning mode fits that as well. A navigation app rerouting around traffic fits that. A spam filter fits that. So does a frontier model writing legal briefs. So does the system that drives a car. The law writes one bracket around all of them. Same bracket, same word. Here's what's strange about that. The people who build these systems don't agree on what an AI system is. The people who study them don't agree. The people who fund them don't agree. Put 3 engineers in a room and you walk out with 4 definitions. The law doesn't have that option. A law needs a stable noun. It needs something a court can point to. So it writes one in legal prose. And the moment it does, the disagreement that existed in the field becomes invisible inside the bracket. This is the part I keep coming back to. I've been writing about this for a couple of years now. The format you write something in decides what the something can be. Walter Ong made that point in 1982. Writing didn't just record speech, it changed what could be thought. Jack Goody made the same point earlier. The list, the table, the formal definition aren't neutral containers. They squeeze the messy thing into the shape the format can hold. A statute is a very specific format. It needs a defined term. It needs an enforceable boundary. It needs a verb a court can rule on. What the world calls AI, what I have called elastic automation in our own terms, is a moving category. It hasn't held still long enough for any field to define it cleanly. The law is asking it to hold still anyway. This isn't a complaint about the law. It's a comment about the format. I've been calling this notation as alignment. Whatever you write something down in, writes back. The notation does the work on the thing being notated. Legal prose is a kind of notation. What it can hold determines what gets enforced. So here we are on May 6, 2026. The text of the law is final. The dictionary on the text is still being written. It will be written mostly by the first cases that get litigated, by inspectors knocking on doors, by companies asking their lawyers whether the spell checker counts. The inspectors arrive in August. The dictionary is still being written. That's the situation. Calm on paper, open in practice. 90 days from now, we find out what the EU thinks an AI system actually is. The notation will do its work either way.